Welcome to another episode of the Straight Up Chicago Investor Podcast. I'm Tom Shawcross, licensed agent with Second City Real Estate. With me, as always, is Mark Ainley, founder and owner of GC Realty. Mark, how we doing?
It's a cloudy Monday morning in a Chicago, start of winter almost. So it's not bad considering. But I guess you had a run-in with a squatter. I'd love to hear more about that you were talking about before.
Yeah, a few hours ago, I thought I was entering a vacant house from an estate sale to go walk it and see what the rehab numbers would be, and ended up having someone in there. Now, Mark, you can probably provide a lot more tips on this. I think even when I started, you provided some of these tips, but anytime I'm going to enter a building, I'll look, front door, back door before going in, peek in there, even if I'm in a north side neighborhood. And we're talking about buildings that you think are vacant. But this is one where it came in, the notice that the People's Gas was shutting off the gas was off the door and inside, which, right there, that was kind of weird, right? Who would take that off? But then the very, very obvious one, oven was open and running, right? So People's Gas is off, gas is off. They're using the oven as heat. Right there, that tells you someone's making a home with this place. So for safety reasons, I turned that off. And at that point, probably should just, leave the premise. I'm a more curious individual. So I did still wander around saying, hello and being a little more cautious, and end up finding my stranger bum in there. But, I guess, Mark, let's take 2 minutes here. Just talk about like some of the safety precautions you should be doing.
Well, hold on. You saw the guy. You can't leave everyone hanging. What happened?
Not much. Just said, dude, like, what are you doing here? And it was a bum either cracked out or drunk or whatever on the floor at, 9:30 in the morning.
Oh, that's boring.
There's no exciting knife fight that's about to happen here.
So did you leave or did
I do carry one of those, little knives. Pretty much the reason I carry is they cut up the carpet to see if there's hardwood underneath. I do have that on me if anything happens.
That's funny. I always do that. I always pull up the rug right around the vent covers. It's usually the most sensitive right there. You usually do it with your hand without a knife. But yeah, you touched on some of the important things of, I was teaching Shay, our new business development person for GC Realty the other day. I always go to the back door. The owner might be live out of state and he's telling you, go check it out. I got a lockbox in the front, go to the back door, push if the door, check the door is open, unlocked. The door might not be open. It might not look like it was busted in, but if the door's unlocked, that's a red flag as well too. You have if you have smoke coming out of the chimney and it's supposed to be vacant, that's usually, if the gas is on and there's heat going, or if there's lights in there, that's a red flag. Or, especially in the winter, you get footprints. So what we're saying here is all, for us, it's on the business development side, but this is if you're looking at bank properties, auction properties, tax sale properties. These are all deemed to be vacant, but in the world we live in right now, you never know who you're going to show up for. And the other big thing I think that I always do, no matter what, when you walk into a vacant property, is to announce yourself in a very loud, kind of confident way. Like, hopefully I don't get in trouble for saying this out loud. I was like, City of Chicago, City of Chicago. And I yell really loud, much louder than I just did there. But then at least you hear, then after that, you stop.
You'll hear the scurry.
And you hear for a scurry. Now, the scary part is sometimes you're not sure if it's a person or a rat. And some of these really like burned out, not burned out, but like these really vacant, like needs a lot of work properties. You're not sure if those are non-paying rodents versus people. But yeah, no, you usually do that. And, for us in the past, if it's proper buy, you say, hey, listen, I just here for the city, or I'm here for the bank, and, they're expected vacant. They're coming by with a whole bunch of people here later on today. So I want to make sure that you don't get caught in that. So you might want to pack up and get out of here. So I've had those conversations. Now, I've heard, maybe we'll have on here for someday a story. I know Jared Kotz sat down on the couch and talked to some of these people and had some heart-to-heart conversation about getting people leaving properties he's owned. But that's a whole nother level that I'm not sure if his risk tolerance is that same these days.
That's a high risk tolerance. I mean, you got to remember, there's part of me that's like, hey, it's harmless, but it's also like, that's someone who has nothing to lose, right? Like, you shouldn't take the matter lightly.
Well, I think back often, and I went to a property on a Saturday about 10 a.m. in Roseland, and it was a HUD property, and I walked in, and there's a guy like blacked out on the floor, and I continued just looking at the property like with one of the business partners at the time, like it was nothing. Now that guy could have woke up with a gun, he could have startled him, like who knows, like you just never know. Like some of those things I did back then were kind of stupid, so I wouldn't recommend doing anything but just kind of, you see somebody, get out of there quietly and report to whoever you need to. Like in that scenario, it might be HUD, or it might be a listing agent, or it might be, for us, it's an owner of a property.
Yeah. One more. And I think, Mark, you're the one who told me this years ago, but when you're going in, I always lock the door behind you as well, so no one's coming in after you.
Yes. Yeah, that's a big one. Now, the thing about that is usually you close that door, it gets dark right away. So make sure you're always prepared with the flashlight if that's the case. But yeah, locking the door behind you. That way, when you're in the second floor and you're in the basement, you hear that door open, you know you got a problem versus just like, so for me, leaving the door unlocked and open, the wind has like scared, taking years off my life, just banging the door against the wall and me freaking out on another level of the house.
Yeah. Cool. So does this count as the housing provider tip? Was this just one long ramble?
Yeah, it was one long ramble. I'll say one more thing too. When you're walking around the outside of the property too, and you see neighbors outside, talk to them.
Ask. There's so much information, even the safety part, but so much info to be gathered there.
Especially if you're going to buy the property, you get a lot of insight, and then that's square one for starting the rapport of your building with your neighbors, so they don't call 301 on you when you actually do your rehab.
Yeah.
So
cool. Well, good stuff. We're going from squatters to evictions here.
Yes.
Heavy episode.
All along the same lines. I had a different tip available. I figure that's way better for today's show. But today we have a returning guest. Today's guest, she was on episode 143, and she talked about the legal aspect and legal side of short-term rentals. We have today back again. And Tom, I looked this up, and if I counted right, we've only had 7 people that have been on the show twice. So you don't get a jacket or anything yet. Maybe third time we'll start handing out jackets. But today I want to introduce Jessica Ryan from KSN. Jessica, she is the principal attorney and she runs the Landlord Tenant Department. She's going to walk us through the eviction process because it's different than it was a year ago. We had Tom Riley about a year ago talking about it. It's different from pre-COVID era times, and there's a whole bunch of other laws and stuff like that in place now too that we want to make sure we stand up. So we're going to go from the decision point of that you have a problem down to I have a couple of questions either today, like, all right, the tenant left and they still have to come get back their stuff. Like, what should we do type questions. So without further ado, Jessica Ryan, welcome back.
Thanks, Mark. Thanks. Good to be back. Mark and Tom, good to see you guys or talk to you guys again. Definitely a lot has changed from pre-pandemic. A lot has changed since during the pandemic. We've got a lot new eviction procedures that have been put in place, and a lot of tenant favorable ordinances and laws have passed as well, kind of snuck in while, all the landlords were trying to figure out how just to maintain their business with no rent. And we turned our backs and several things passed through. So there is a lot to talk about, a lot of changes since last year when Tom was on.
Awesome. Well, let's dive right in here. And I talk to people all the time. I'm sure you do too, Tom. They're like, this tenant has to pay in 6 months. And I think I got to start the legal process. Now, I can confidently say that is the wrong approach. But I also get people, it's like day 6, I deliver 5 days. Should I file? I think that's too aggressive an approach. Like, what do you recommend to your clients, or what do you see as being a best practice kind of from your point of view when it comes to like, I got to serve a 5-day to actually really potentially go after the legal part of this?
So we actually recommend serving a 5-day after the grace period in the first month of unpaid rent has passed. So if there's a grace period of the 5th of the month, serve your 5-day on the 6th of the month. If it's the 10th or the 15th, serve your 5-day the day after the grace period expires. Do this consistently with all tenants who have not paid. I understand some tenants will tell you, we're coming up with it. We'll come up with it by the end of the month. But it's really important to have a consistent policy in place. Okay, I understand you guys are going to come up with the money, but it's my policy to serve a 5-day notice after the grace period has ended. So I am going to serve you with the 5-day notice, just like I serve everybody. The consistency, one, is going to protect you from discrimination complaints, which is always really, really important, especially in Cook County and Chicago. And you also get a nice, consistent feeling back from your tenants. This landlord is serious. This landlord is always going to serve the 5-day notice. I'm not going to get a free month. And that kind of spreads among your tenants, and it actually encourages payment in the future. You just set up a consistent policy across the board, and tenants kind of start falling in line, and you will end up getting more consistent payment if you consistently put out 5 days. Now, for filing, if you have tenants who are saying, hey, we can pay by the end of the month, I'm not saying you have to file your case immediately after the 5-day notice has expired. if you're working out payment plans, if they're telling you you're going to pay, you can make the decision whether to file on that 5-day notice once it's expired or give the tenant a week or two extra.
Break down, we'll go very 101 here, a 5-day notice. When you are delivering a 5-day notice, what is it and what are you really doing to those? What are you saying, I guess, in that message?
And do you have to physically deliver it to the tenant?
Yeah, I was going to go on that too. Like talk about process server versus physically versus posting. Give us kind of that spiel.
Yep, absolutely. So we refer very generally to a 5-day notice as a termination notice for non-payment. So when your tenant hasn't paid and you want to terminate their tenancy for non-payment, you have to serve them with a written notice. We use 5-day because Illinois statute says the minimum amount of time you can give a tenant to pay is 5 days. I always caution clients, landlords who use a lease that might be off the internet. It's not one of the standard leases. They're, multi-state and they're using their lease from Indiana in Illinois. Leases that are not in compliance with Illinois law could say you have to give your tenant 7 days or 10 days to pay. Some even say 3 days, but it's 5 days in Illinois unless your lease says more. So just be careful. Always look at your lease and make sure you can use a 5-day notice. I'm going to use that term just because it's the standard, what we talk about in Illinois, but I'm throwing that caveat out there. So a 5-day notice is going to tell the tenant how much they owe and give them 5 days to pay in full. You got to have the tenant's name. You got to have their full address. Write the word street or avenue. Make sure the unit number and the zip code all included and have the proper address in there. You want the amount that's due through the date you sign that notice. So make sure the full amount of rent is due. In Chicago and Cook County, you should only include rent. You should not include late fees or repair charges or utilities unless your lease says that those amounts are considered additional rent. Judges do not like to see landlords throwing in every different amount due. They only want to see rent. So that's a little lease provision tip there. Your lease should say that everything that the tenant has to pay is considered additional rent. And then you can throw everything in the kitchen sink into your 5-day notice. So we've got tenant name, full address, the amount that's due. It has to tell them that they have 5 days to pay. Then there is some statutory language in Illinois that says to the effect of only full payment will waive the landlord's right to pursue termination of your tenancy. But it's very specific statutory language that has to be included. So don't pull a termination notice off of, a website for California notices. It's got to have this Illinois statute language in there. And it has to be dated and signed by the landlord. Now, there's some other technical issues that tenants' rights attorneys sometimes bring up. I've had arguments that the 5-day notice should include where payment can be made. We have generally overcome those arguments, and the judge agrees that if the tenant has been paying rent regularly, they should know where to pay the rent. So just be careful. Another argument that has been made is whether the person signing is actually the landlord or an agent. Is the landlord identified on the 5-day notice? We have overcome those arguments as well, but it may be good under the landlord signature line to either put ABC Management as agent for owner or the ownership ABC Property LLC as the landlord's name. So just a few technical requirements. So that's what needs to be included in the 5-day. Really, really important. I'm glad you guys brought up service, because service of a 5-day notice in Illinois, especially in Chicago, is really, really important. So Illinois statute says you have to serve by personally handing it to someone, either the tenant or any occupant who is 13 years or older, sending it by certified mail, or posting on the door if no one is actually in possession of the unit. So let's talk about those first two. You can hand it to the tenant. That is the best way absolutely to serve a 5-day notice. You can hand it to any occupant who lives there who's age 13 or older. So, if the tenant has a 13-year-old son, you can hand that 5-day notice to the 13-year-old. Certified mail. Judges want to see a green card with a legible signature of the tenant. Those are very hard to come by these days. Not only is it really difficult to get the green card back, when you get it back, there's some scribble on it and you absolutely cannot make out who signed it. And the judge is going to say that's not proper service. Last is posting. And this is the one that gets landlords all the time. I hear, it says I can post it. No, it says you can only post if no one is actually in possession. So the statute requirement is that you can only post if the tenants have abandoned the unit, but they left a bunch of stuff in there and you want to be, really safe and go the eviction route, but they're not living in there. Then you can post it. Otherwise, you have to try to personally serve the tenant. In Chicago, I've had judges say, you could sit outside that unit 24/7. I bet you'd get him. Can't post it. Need to personally serve it. The judges are really, really sticklers for personal service. So our general rule of thumb that we tell clients is 8 to 12 attempts at personal service. Write down the date and time that you made those attempts and what happened. You heard the TV inside, nobody came to the door. The tenant's car's in the driveway, nobody came to the door. Dog barking, nobody came to the door. After those 8 to 12 attempts, then post it, mail it regular mail. If you have an email address for the tenant, email it to the tenant as well. Then from our office, we have our clients sign what's called an affidavit of due diligence, where we are having the client testify in an affidavit as to all the different service attempts they tried. When we do that, we've been very successful. We have not had a case dismissed for posting when our client has followed all of those rigorous requirements, but it is time consuming. But I will tell you, absolutely in Chicago, if you post a notice without attempting personal service, the judges will dismiss your case. As soon as they catch it, they will dismiss your case. They want to see the notice before they enter an eviction order, and they will catch it, and your case will be dismissed. So that posting gets landlords. But in Chicago and Cook County, make sure you are attempting personal service at least 8 to 12 times before you post.
Yep. So a couple random questions here about servicing. This is all great information, Jessica. I've heard landlords do the, serve the notice to enter. Like, hey, I'm coming in 48 hours. Like, here is the, whether it be email, slide under the door, and then, knock, knock. I'm notice to enter. You've been given your warning, and try to serve that way. Do you see issues with that? And then also, what about servicing them outside of the unit? Where they were. This is getting pretty extreme, but are those other avenues if you have to go that route? Yep,
absolutely. So you can definitely give them a notice that you're going to access in 48 hours, and hopefully they will be there, and serve them with the notice at that time. Absolutely. There's nothing wrong with that. I have had management companies in big buildings, at the barbecue, they give special invitations to the tenant that needs service, and, oh, make sure you're coming. We'd love to see you. And the tenant comes down and they serve them with the 5-day notice. I've had clients use package delivery when there is a package, but make sure they have somebody monitoring when this tenant has a package come in, and that person is standing there in the package room waiting to serve the tenant. So definitely you can use different methods to lure the tenant into receiving that notice. And second, yes, serving offsite is fine. The difference is when you serve at the unit, if there are 3 leaseholders on your lease, 3 tenants named on your lease, at the unit, you can serve one of those tenants and it counts on all of them. That's called abode service, or service at the dwelling unit. If you get one of them, it counts on all of them. If you are serving them offsite at their employment, you can do that, but it only counts on service on that particular tenant. So you would have to go to all 3 of their places of employment to get them served versus just serving them at their house. But if you've got one tenant and you know where he works and he's there from 6 a.m. till 9 at night or something insane, and you can't get him at the property, you could definitely serve him at his place of employment.
I got a buddy of mine that's got a newer building that has the fire system in there. He pulled the panel and alarm went out. He's like, I was glad to pay the $500 fine to the fire department, and I was able to get him served when they came running out to get the building was on fire. So
yep.
There's different levels of creativity. For the personal service though, what if you knock on the door and the tenant's brother answers the door and he's obviously over 13, and you hand it to them? Is that talk to us about that? Is that acceptable because they're over 13 and they're in the unit? Tell us more.
It has to be somebody who resides in or is in charge of the unit. So, it depends. If the brother's visiting for the afternoon, no, that's not going to be good service. If the brother is staying there indefinitely, as an unauthorized occupant, yes, that would be good service. So you kind of have to get a little bit more information from the person you are serving if it's not your leaseholder or an authorized occupant that you know of. You've got to know how long are they there? Are they just hanging out for the afternoon, or have they moved in temporarily? Who are you? What's your name? Get as much information about that person as possible.
We've moved a lot more towards process servers because the amount of time they can put into it, the amount of information they give back, like they're pretty detailed, right? They talk to us about using process server. Is that do people like yourself look at that as a positive?
Well, we do, absolutely. I think it makes life a lot easier. As far as going to court with an affidavit of service, your process server affidavit is always going to be more detailed. I think the judges, not that they don't give credibility to landlords who fill out their own affidavits, but seeing the same process server affidavit over and over, they know these process servers don't have a stake in the case. And, it's just honest information included with all of the detail. On the flip side, there's a cost for a process server, obviously. And if time is really of the essence, if you're really, really in a time crunch, maybe it's a conduct case and you want to get a 10-day notice served as quickly as possible. When you use a process server, it's generally they get the first attempt in about 36 hours from the time. That's usually what the couple process servers we work with tell us, about 36 hours from the time they receive it, and about 36 to 48 hours after that, each attempt is made. So they're not going to your property every day. They're not going to go the same day that they receive it. So if you really want to get that notice served immediately, it's better off if you do it, because you're going to be able to do it every single day. If you are having problems serving and you got to go through that process of 8 to 12 personal attempts before you post, my clients don't want to use a process server because it's going to be like every 2 or 3 days that they're getting it, when our client could go every single day and make an attempt. So there are definitely pros and cons. Of course, as an attorney, I love to see an affidavit from a process server because it's very clean, it's very reliable, and it's.
I see a lot of landlords give up, or they'll get mad one day, they got to drop the 5-day, and then they never go do it. But I always tell them, just send it to the process server. Then it's there's no point of return at that point, and it'll get done before you get mad about it next week when you stop focusing on work or something like that. So sometimes it helps.
Either are you going to make it a priority or not, right?
Yeah,
if not, punt. If someone else
exactly.
Well, time too. Like if you're in the north side and you have a property on the south side, if you got to go another 2-3 times to find them, like it's cheaper to pay the $85, whatever it might be, $75 to $100 to do it. Like I think
you're going to spend more on gas.
Yeah, I think that was one of our tips recently on the show here. It's like, what's your time worth? Like sometimes that's how you got to make that decision.
Absolutely. So
what happens next? We serve the 5-day gets in their hands.
Yes.
You're being served. What happens next?
So you've got to give them that 5 days to pay in full. I will say, I'm just going to throw in really, really quickly, be careful of partial payments, turn off their ability to make automatic payments, have your staff on alert not to accept anything but payment in full. If you accept a partial payment, you can no longer proceed on that 5-day notice. So your options are either accept the partial payment and issue a new 5-day. I mean, especially if they come in the office, just say, hold on, let me get you a receipt, and then go back and type up a new 5-day for the remaining balance and say, here's your receipt for that payment, and here's your new 5-day for the remaining balance. Easiest way to get that done if you want the money in hand. If you'd rather just get them out, reject anything but full payment in those 5 days.
What about people that sneak in payments? Like they might mail it to you or they drop it off on the weekend. Can you just return it? Like
Return it immediately. If it
Okay.
is mailed to you or dropped off, like, in your lockbox or something, return it immediately via FedEx so that you have a record that they received it back.
Okay.
And don't wait 2 or 3 weeks to return the payment. Return it immediately so that you can show that it was never intended to be accepted. So once that 5-day expires and they haven't paid, you're eligible to file your eviction lawsuit. So you file with the clerk of the court. The clerk has a whole e-filing system, which is fantastic. So if you are high volume and you're registered or an attorney's office like me, you can e-file. Otherwise, you go down to the clerk's office and wait in line with a bunch of paper copies and file on your own. I will say
we got to go back.
ahead.
We got to go back. The most asked question is the 5 days. When does it start? Does weekends count? Like, come on, that's just this. Just for this question.
Yeah. Absolutely. Okay. So they have until midnight of the 5th full calendar day to pay. And we'll talk about holidays and weekends in just a second. So if you give it to them on the 15th at any time of day, they have the full 16th, 17th, 18th, 19th till midnight of the 20th. So you cannot file your lawsuit till the 21st. So 5 full calendar days. Weekends, it's an odd rule. And holidays. If the 5th day ends on a weekend or holiday, they get the extra day, because the idea is they can't make payment on that 5th day if they're waiting till the last day.
So judges, if the 5th day is on a Saturday, Sunday, or holiday, they basically get one day.
They get all the way Monday. Yes, they get till midnight on Monday to pay, and you could pay on Tuesday. Back in the day, there were some judges that would say, if your 5 days falls over the weekend, even if it ends on Monday, they get 2 extra days because we're not counting Saturdays or Sundays or holidays. That's generally not the rule anymore. I have not seen judges enforce that idea anymore, and that's definitely not how the statute is written. So usually it's just if it ends, if the 5th day is on a Saturday, Sunday, or holiday, they get 1 full regular calendar day till midnight to pay before you can file. So good question. That is really important. Yes.
Huge.
Yep. When I gave seminars, I used to throw out candy. Like to keep people interested and awake, I would always ask questions through my seminars, and I would have full-size candy bars and I would toss them to the people. That was always one of my questions. If you file on the 15th, what day is the first day you can file your eviction case? And whoever yelled it out first would get a Snickers.
So that's awesome. So when you file, there's what seems to be nowadays a large fee. A lot of people are like, I don't want to pay an attorney, or the attorney fees are so much. A lot of that attorney fee bill you might send isn't even your cost. Like break down the county's getting a piece, the filing fee, break down some. I think you'd be specific on the Cook County fees of what those are.
I can, yeah. So Cook County, I think right now it's $356 just to file the eviction lawsuit when the amount of rent is under $50,000. So if you're one of those landlords who have really put off your pandemic filings and you have over $50,000 on your rent roll for one tenant, you're going to be paying close to $500 to file your case. But most landlords were under $50,000, but it's still $356 to file the lawsuit. Then in Cook County, you have to use the sheriff to serve the first time around. Collar counties outside of Cook, you can go right to a process server, but in Cook County, you have to give it to the sheriff. And the sheriff is $61 per defendant, per tenant, including all unknown occupants. And you should be naming all unknown occupants on your lawsuit, because when the sheriff comes out eventually to perform the eviction and Joe is sleeping on the couch and you did not name all unknown occupants, they'll say, we don't know who Joe is and you didn't name unknown occupants, so we're not performing the eviction. So unknown occupants, and each person listed on your complaint with the sheriff is $61. So if you have one tenant and unknown occupants, it's $122 on top of the $356. So, you're up there around $800 always just getting your case filed. It's a lot because you will be using the sheriff and then generally a process server if the sheriff doesn't make service. So yeah.
Right. Real quick, how do you file? Right. Like I've never done this before. Where am I sending this? Like who?
So
right, like what's the step?
Okay. So by the end of this podcast, I don't think any landlord is going to want to do this on their own after they hear how insane Cook County is right now, with some post-pandemic mandated procedures in place. But if you are doing this on your own, you probably do not have or do not qualify for e-filing registration. It's usually just high volume filers and attorneys who are registered. So you would actually need to take paper copies down to the clerk's office, either in the Daily Center or in one of the Cook County suburban districts, and file your case. There are instructions on the clerk's website as to how many copies you need. You need a complaint. The complaint is like the factual allegations of what happened, and a summons, which gives the date and time of the first court date. There are forms. The Supreme Court has come out with standardized forms to be used all over the state of Illinois. So it is, it's possible, and it's probably not too difficult for a landlord to file the case on their own using the Supreme Court forms, and showing up in person at the clerk's office to file it. It just gets more and more complicated from there.
I'll just add something to this. If you're listening to this and you're thinking that's a great idea, I'm going to go do that, you probably shouldn't be a real estate investor, because you're going to drive yourself crazy and you're literally stepping over dollars to pick up pennies. So I just want to make sure I'm putting that out there. It's some raw evidence of people I've seen like that are often just shoot themselves in the foot as a landlord.
Yeah.
Well, this goes back to, and I know sometimes people have a hard time swallowing their pride, but if you can get them out, even if you have to pay them, like it's easier. Like it sucks.
Yeah.
You don't, they've been screwing you over, and yet you're going to write them a check. But like at the end of the day, your business is probably in a better situation. And that's all that matters. It's not a pride thing. Is your business going to be in a better situation making this move or not?
Yep, exactly. I constantly have the business decision conversation with clients. Like, this is not about the principal. This is a business decision. Write them a check. They will get out. They filed a jury demand or whatever it might be. This is going to cost you thousands of dollars, and they want $1,500 to move. Write that check.
Yeah, the amount of risk too to do it yourself. Like, I don't know, it blows my mind. People, I think that's a good idea. So, it's assuming people are going to hire KSN, they email you, you onboard them. What do you guys need as an attorney, or I guess probably most law firms would be the same. What do you guys need to proceed for a client?
So we need the lease, a copy of the lease, the written lease, an account ledger that I can show the judge. So not a handwritten page of scribbles, really a nice account ledger would be good. And then if you served your own 5-day notice, the signed served 5-day notice. So that's it. Those 3 documents. And we generally get the complaint on file within 24 to 48 hours, assuming that there are no issues with it. And once it's on file in Cook County, I will say in the Daily Center, the suburban Cook County districts were getting 30 to 45 day court dates. The Daily Center in Chicago, so if you have a Chicago property, your first court date is going to be about 60 days out. That's way down from during the pandemic. I know it sounds horrible that you're not going to get into court for 2 months when you will have unpaid rent, but during the pandemic, we were somewhere between 70 and 90 days for a first court date. So yeah, it's a hard pill to swallow, that first court date being 60 days out. You get that back. You can't believe it, but that is the standard.
So waiting for that first court date, that's where the Cook County Sheriff is going out. What's the success rate you see? For me on the street level, I feel like it's like 10%, but what do you see like as a whole view, I guess, of them actually getting it done? It
is somewhere between 10 and 20%. Okay. I think pre-pandemic, it was 18%. Someone had actually done the math. And I had heard it was about 18%. So it is unlikely. They often make 1 to 3 attempts maximum before they return it unserved. If you get 3 attempts out of the sheriff, that's fantastic. Sometimes they will just go out one time and attempt to serve and return it unserved. So it's unfortunate. We get returns from the sheriff within about 3 weeks after we give it to them. And we've got another 5 weeks till the court date. And we're like, no, take it back. Keep trying. Like there's more time. And they're like, nope, we're done. We made 3 attempts. That's it. It's unserved. So it can be very frustrating. Be prepared to get a second summons when you go in for that first court date. Be prepared that you'll probably have to issue a second summons and use a process server at that time. We are always prepared. We have standing orders with the clerk's office for our process server. So we don't have to appoint it each time.
So the long awaited court date comes and frankly, 90% of the time you can't do anything with it, but ask for an extension. So you could use, am I understanding that right? Am I saying it right?
That's correct. So in January of 2021, the Supreme Court of Illinois put a mandate in place that every county has to come up with some type of mediation program in their eviction courtrooms. It was to deal with what they thought would be the tsunami of evictions because of the pandemic and a way to protect tenants who had been financially impacted by COVID. The broad stroke that they made, though, was that it protected all tenants, no matter whether they were financially impacted or whether they just chose not to pay rent because they knew that they could get away with it during the pandemic. So every tenant is entitled to this eviction mediation program. In Cook County, and it was left up to the counties how each circuit court wanted to implement it. So in Cook County, they came up with the ERP, or the Early Resolution Program, which is a misnomer because there's nothing early about it. It just delays the case by about 3 to 6 months. So when you get into court, after the case has been served, so either it's served by the sheriff or a process server, and you get into court, you've got service. If the tenant does not show up, you are still going to get a continuance. So pre-pandemic, we could get a default eviction order right then at that first court date. If we had service and the tenant wasn't there, the judge would give us an eviction order by default. That will no longer happen. We will get another continuance between 2 to 4 weeks for us to notify the defendant that there is another court date, there's another opportunity for you to appear. And then possibly at that next court date, we could get a default eviction order. Some judges still feel bad and give one more continuance. That's if the tenant doesn't show up. If the tenant does show up once they've been served, the case is automatically put into ERP. And there's a 30-day continuance in which the tenant has an opportunity to file for rental assistance, talk to an ERP mediator, who is just a volunteer who has some training in the ERP program, but really not a lot of knowledge about the landlord-tenant relationship or even the eviction process, which is unfortunate. And we find most cases that go through ERP, the ERP program does not resolve anything any more quicker than we would be able to resolve it if we could negotiate directly with the tenant. Most of our landlords have always been open to payment plans, extended days for move out, whatever it is. I mean, like you guys say, landlords kind of understand sometimes you got to swallow your pride to get an agreed order on the table. And we've been able to do that. And the ERP kind of ties our hands. We don't have access to the tenants. We have to go through these ERP mediators who don't really understand the process, or the tenant never reaches out to the ERP mediator, and the ERP mediator is not affirmatively going after the tenant. The tenant has to take these steps on their own. So we're sitting on a 30-day continuance when the tenant may or may not apply for rental assistance, talk to the ERP mediator. You go back on that 30-day ERP status date. If the tenant hasn't done anything, but they show up and say, "Oh, judge, but I meant to apply for rental assistance," they'll get another 30-day date. And they'll get another opportunity to go through ERP and try and take advantage of some of those things. And then only if we are unable to resolve it, if the tenant hasn't done anything after being given all of these opportunities to take advantage of the help that's out there, we go back into court, and then they will assign us at that point to an eviction courtroom. So the judge who's doing what we call like the ERP or the intake, the eviction intake process, does not really make any decisions on the substance of the case. Only when the tenant has exhausted all of their help and we're unable to resolve it, then we get assigned to an eviction courtroom. So that's another continuance. And once we get into that courtroom, we can either have a trial, a hearing, prove up how much is due to get our eviction order, and finally have a judge who has the authority to give us that eviction order, to hear the substance of the case and give us that eviction order.
So two questions. One, did the tsunami as expected ever really happen as bad as everyone thought? I mean, and then two, do you ever see this ERP piece being removed anytime soon?
So I'll hit that last one. First, ERP by Supreme Court order is in place until December 31st, 2023. So we've got another year of that.
And you're going to say 22.
No. There's already some rumblings that tenants' rights groups are trying to push this to be permanent, which is a huge problem. And so on your first question, whether the tsunami actually ever hit, no. Based on my conversations with other landlord attorneys, and I'm in a couple of landlord attorney groups, our numbers never exceeded what they were pre-pandemic. So the eviction ban lifted October 3rd of 2021. Everyone thought from November till maybe March through first quarter of 2022, it would just be this insane number of evictions that would clog the court system. And that wasn't the case. I mean, many landlords worked out payment plans, deferred rent, waived rent during the pandemic. And the ones that needed to go forward with 5-day notices were mainly like the ghost tenants, the tenants that never responded to these offers or that were kind of milking it. You know, we knew they were working, we knew, they were doing okay and hadn't lost jobs, had not reached out for help, hadn't shown any, financial issues. And those were really the tenants that landlords had to file on after the pandemic. And those were the tenants that you had always filed on, the ones that wouldn't work out anything with you. What the problem became and what was interpreted as a high volume of evictions was not the number of evictions, but how they were being handled in the Daly Center in Chicago. Because there's 5 eviction courtrooms. And they were always, a new case was always assigned to one of the 5 courtrooms. But with this ERP program in place, there were only so many ERP mediators, and they didn't have enough volunteers to spread among 5 courtrooms. So they couldn't get enough ERP mediators to be sitting in all 5 of those courtrooms to hear these cases. So the way they set it up is that all of the new eviction cases were assigned to one courtroom where the ERP mediators would be. And that's when I refer to that like intake eviction courtroom that didn't really have authority to hear the cases. That's the one courtroom that gets assigned all of the new cases. So if you can imagine, 500 a day evictions or whatever the number might be getting filed that used to get spread among 5 courtrooms now had to be funneled into one courtroom. It was a bottleneck, and the judges' court calendars were getting filled up, and every day was getting filled until we were getting return dates 90 days out because all of the new cases had to be assigned to one courtroom instead of 5. And that was interpreted by many tenants' rights groups as the tsunami of evictions. But it wasn't the tsunami of evictions that was causing the delays. It was the way the ERP program was implemented due to short staffing.
Gosh, that's stupid. Self-created.
Yeah. Yes, it was. Yes, it was. We attempted many times to sit down and put in some creative resolution, but we were always told they just didn't have the staff to fix it. So this is where we are. This is where we still are. So
Before we go any further, I just want to outline some of these timelines real fast. So 45, 60 days to get to court date one. That's with a sheriff going out and attempting service. If it comes back on that first court date, how long is the extension to the next court date where we can now send a process server? How many is that? Another 30 days?
You can pick it. Usually we do about 3 weeks because you have to file a new summons and then get it to the process server and give them time to serve.
Gotcha. Okay. So you have to file a whole new summons as part of that. Okay.
Yes.
And then you come back and either the tenant shows up or it doesn't show up, but then you get another automatic extension at that point for the ERP. And that's another 30 days, correct?
If the tenant shows up, it's 30 days. If they don't show up, it's 2 to 4 weeks. Yep.
Gotcha. So it's 14 to 30 days. Okay. And then they
days are adding up here.
So we're at court day or court 4, and we're basically that's 110 days into the process. Recap again if you didn't already. What then? Court 4. That's either they're going to come and ask for another extension because they didn't do it, I think is what you said.
Yep.
Or you can actually get a. Can you get a possession judgment at that point?
No, because that'd be too easy, Mark. No, if they have shown up and you're unable to resolve it during this ERP continuance, then we are assigned to an eviction courtroom and we get about a 30-day court date. And in that eviction courtroom, when we finally go in about 30 days later, that's when we can get the eviction order.
Gotcha. So it takes, in what we're saying are basically 5 court dates to get 5 court dates and 160 days to really run or 130 to 160
Sheriff's
days.
still got to come out. We're not done.
Yeah, no. I'm just saying that the court part. Yeah. So
just the court process. And landlords should be aware as well. Another caution against trying to handle this on your own. Court is on Zoom. So you are not there in person to hand a paper continuance order up to the judge for the clerk to stamp, and you get that paper order back. You get the judge's direction. Yes, we are going to continue it to such and such a date, send an order in. Then you have to digitally email or upload your draft order to the judge and wait for the judge to sign it, the clerk to stamp it, and then get emailed to you, which rarely happens. We have someone, and I know I've talked to other landlords' attorneys who have actually taken on a staff member whose entire job is to email and call the clerk's office to get stamped orders. So this happens with the continuance order when you're assigned to an eviction courtroom, because the judge doesn't say you will be in 1406 on such and such a date. They say transfer to an eviction courtroom. And then we wait for the order to come to us that tells us what that date is and what that courtroom is. And we have to call and follow up. Not only that, when you get your eviction order, the judge says, I'm awarding you an eviction order with this much in rent and your court costs. And here's the date that the tenant has to move out. Send in a draft order. We can't get those stamped orders back. So the judge may give a 7-day date that the tenant has to move out by, but we can't get that eviction order back for 3 or 4 weeks to place it with the sheriff. So we literally have a person who is just constantly calling and emailing the clerk's office to get these signed orders back. So the whole Zoom component has really complicated the eviction court process as well. And it's very frustrating when you should be able to place it with the sheriff. You can't because you don't have a stamped order back. So lots and lots of delays before we even get to the point of being able to ask the sheriff to come out.
What about possession versus judgments? I may be saying it wrong, but I know the conversation often comes up in our circles of like, you just want possession back. You're not looking for a money judgment. Talk to us about that and those conversations that landlords need to be having at this point or at some point during here.
Okay. So landlords often give me that directive because they think it's going to make it faster. And that's not the case. You can only get a money judgment against a tenant if they have been personally served with the lawsuit documents. So if the tenant is served by the sheriff or the process server, you're going to get your money judgment along with your eviction or possession order. If you are unable to get service either of those ways, you can resort to what's called notice by posting. Sounds a lot like posting the notice. It's not. Because it's the lawsuit, the notice by posting is a document that the clerk issues, and the sheriff mails it to the tenant and posts it in the clerk's office or in the courthouse. There's this like arcane idea that every citizen is going to walk through the courthouse once per day and check notifications. And we're still going as if that's the case. So that's what the posting is. The sheriff is actually posting a notification that this lawsuit is on file against the tenant. If we go that route, we just get the possession order, and you're not allowed to get a money judgment that's like attached to the tenant, right? Because we didn't get personal service. So I have clients say, don't do that whole service thing. We'll just do posting because we want to get just possession. We don't care about the money. This tenant isn't collectible. Just push it through and just get possession. It doesn't matter because the judges require attempts at personal service, especially in Cook County. In the collar counties, we might be able to expedite it a little bit, but in Cook County, the judges will require one round of service by the sheriff. They will require a second round of service by the process server. Some judges even require a third round of service by a process server to try to get these tenants personally served before the judge will even authorize notice by posting, which would result in that possession judgment. So that's the difference. That's kind of the process. But I just want to warn everybody, just saying, hey, possession only doesn't actually make it faster.
Yep.
We'll come back to the judgment part at the end there. As far as so next steps to get to that final court date, you've gotten some attorney fees along the way for your 5 court dates, but now you have to file with the sheriff to actually enter the eviction order, and there's an additional fee there, correct?
Yes. Sheriff's fees. So you have to get a certified copy of the order. I think that's only like $12, and then the sheriff's fee. It seems like it's not going to be too much. I think it's like around $60, I think, to file it with them. But then if they are there more than, I can't even remember what it is, an hour, I think it is, then you will get a second invoice for their time. So it seems like it's not too much, but there is definitely another fee coming down the road. But all in all, you're going to be somewhere probably $150, $200 for them to actually perform the eviction, as long as they're not there for hours and hours.
So now you go into the depth of waiting, and it feels like it's never going to happen. Like what type of timeframes have you seen recently from the time you place it with the sheriff to someone actually shows up?
So it's actually not so bad. For a little while during the pandemic, it got slow, but I feel like the Cook County Sheriff actually put some effort into getting their timeframes back to where we were pre-pandemic. So they're at about 3 to 4 weeks from the time you place it till the date that they actually show up. A couple of warnings. One, you get notification less than 24 hours in advance. So we usually get a phone call around 3 p.m. for an eviction that's 8 a.m. the next morning. And you have to have someone at the property to meet the sheriff. So it's very, very little warning for you to be prepared for this eviction. We're not getting the date a week in advance. It's less than 24 hours. That's one. Two, Cook County puts a moratorium on evictions. So they kind of hold evictions during the winter. So it's usually from right now, like the second week of December through end of the first week or the second week of January, that they will not perform any evictions at all. Any eviction that they have received in the last week is going to be held until mid-January. And then over the winter months, they do not perform any evictions when the temperature is below freezing. So, if tomorrow is going to be freezing, they're not going to schedule any evictions.
I thought that was a myth. I thought the moratorium over the holidays was a myth, because if it's not, then I actually owe my business partner an apology. I tried correcting him the other day in front of people.
Yeah, no, it's not a myth. It's not a myth. It's an order that goes out every year, giving the dates of the moratorium.
All right. Well, Brian, if you're listening to this, I apologize in front of everybody.
All right. So this is an insane timeline. I want to take one step back here. As the housing provider, you have outsourced this to someone like Jessica. Mark, can you and I just talk real quickly some best practices on what we should be doing in the interim, right? Because the unit can be getting trashed. You still might be getting work orders from these people, right? And then also let's talk about the actual, just being ready to change the locks the day of as well when the sheriff's actually getting there. Like, let's talk through some things we can control and can do.
Yeah, well, I was going to ask because I know there's things that we do, and I'm not sure if it's ever in the favor of the attorney as far as best practices. But I guess, Jessica, during this entire, call it 3 to 6 month period, like what is your expectation for landlord? Because I know for us, we're trying to still negotiate them out or see if they entice them to leave. Or I think it's the efforts turn from collecting rent to getting out more so. Or we're talking about cash for keys and stuff like that. Or again, we're doing if it's a problem tenant, there's non-paying tenants and there's problem tenants, right? Problem non-paying tenants. So we're doing drive-bys. We're making sure the lawns are getting cut, especially in the suburbs where the fines are like. Those are definitely some things that we're always trying to keep an eye on. And then the other thing I think the risk that landlords have is they leave and you don't realize it. So they leave, electric gets turned off, and you have a basement, and your basement gets flooded because the sump pump went off. That's something that we have on our every 3 to 5 days. Some we have a process for, but we have one guy that literally calls ComEd to see if they turned off power yet for that particular unit. So Tom, what else do you work on, Tom, on your side?
I would say just constant communicate, even if they're not going to respond to you, just going there as much as possible. I mean, one, you want to know if they're trashing the place, right? Are these people, that new rehab you did, is it just demolished, or are they just sitting there not paying? Neither one's a good situation. One is definitely way worse than the other, right? And maybe you could strike up a conversation with someone that'll say, you know what, this is my number, right? Like, things change for people. No, they're not going to give me, they're going to give me, well, it's my third court date. This is actually going to happen. What do I do now? Like, some people will have a turn of heart, others won't, right? Others just don't care at all. So, but I guess I was going to go on the same path you did of like, if they left, like, you need to know that, right? You need to know, like, is gas on? Like, is a pipe going to burst? Like, that's when it can almost be a bigger problem.
Yeah, it's a success story approach that happened to me recently. I sat in the property management seat for a little bit this past summer, I guess. And we had somebody in a tenant we inherited that came on board as a problem. But what I did is I went to the physical property and I told the neighbor next door, I said, listen, give you $100 gift card for Morton's if you let me know the day they move out. And sure enough, 3 weeks later, I gave her my number. She sent me a text. She's like, they're out. They're finally out. Thank you. So I gave her $100 gift card, but we might have caught it in the next week, but I knew literally real time through the neighbors. A lot of times when you have a problem tenant, a non-paying tenant, the neighbors most likely don't like them either. They're either doing something that's unsafe to maybe their kids, doesn't look good on the neighborhood. So those people they're your allies in those scenarios, and utilize them to feed you information because you can't be on the property every day, and they are right next door. Yep.
And so let's also talk about, they put in a work order. They got a clogged toilet. And my understanding is, like, you still got to go service that like you would a paying tenant. Is that, Jessica, that's accurate? Otherwise,
habitability, right?
Yep, absolutely. Absolutely. You have to continue maintaining that property, even though they are not paying you a dime. It is very frustrating, but you have a duty as a landlord to take care of that property.
Got it. All right. And then let's talk about, Mark, unless you have anything else to add there, let's talk about the actual day the sheriff comes out, right? Like, being ready, the best practices there.
Yep, absolutely. So you have to have what they call a receiver, which is a person at the property to meet the sheriff. Do not go to the door of the unit to negotiate some kind of move out without the sheriff. Horror story, we actually had a property manager get shot through the door with a shotgun. Horrible. So do not go to the door until the sheriff arrives. That's my biggest best practices safety tip. Second, you need to be like standing there waving your arms for the sheriff. The sheriff's car will literally slow down and look for somebody. And if they don't see anybody, they're just going to keep driving. And then you're going to have to reschedule your eviction. So make sure you are there 20 minutes before, half hour before, ready, standing outside your car. And when you see that sheriff's car, you wave them down and you let them know, you identify yourself right away. I'm the receiver for this property, for this eviction. It's always good to have a paper copy of your eviction order printed out. They will want to confirm with you what unit is getting evicted, and you need to know it's 3F. If you say 2E, they're going to be like, no, that's not the unit we're supposed to be evicting. And they get skeptical, and they will not perform it unless that receiver can actually confirm all of the information to confirm that that person really is there for the correct one. So have a copy of your eviction order ready to go. You need a locksmith to change the locks. And you should have 3 able-bodied movers, 3 people who can move all of the stuff out. It is always my recommendation that you move the tenant's stuff out on the day of the eviction. I have a lot of really nice bleeding heart landlords, and the tenant says, oh, please don't put my stuff on the curb. I'll come back tomorrow with movers. I just wasn't prepared. I didn't really think this was going to happen, whatever the tenant's reason is. And the landlord says, okay, you just get out. We'll change the locks, but we'll leave all your stuff in there and you just call me and we'll schedule it. I mean, that could go on for weeks, months, that the tenant is saying, I'll come back. I'll come back. I've had landlords that said, oh yeah, the eviction was successful. They're going to get their stuff tomorrow. I don't hear from my landlord for 6 weeks. And all of a sudden the landlord calls and says, so it's been 6 weeks and they keep telling me they're going to pick up their stuff and they haven't. I'm like, 6 weeks? Like, why didn't you call me after day 3? Like, what are you doing? So I first do not recommend that to begin with. Second, if you go that route, 7 days max. I say day 3, if they have not picked up their stuff, you then can issue a letter that says you've abandoned, by ordinance, you have abandoned your belongings and your tenancy has been terminated and you have been legally evicted. You have X number of days to get your belongings. Now, standard is 7 days to get your belongings or they will be discarded, which is why I say on day 3, if they haven't picked up their stuff yet, give them the notice that in 7 days, everything's going to be thrown out. So that's the standard. Don't let it go 6 weeks. If they keep giving you the runaround and making you promises, don't be gullible. After the second promise, issue that notice. Be done with this. Get your property back so you can turn it. Don't let that tenant take advantage of you.
I tell people they just took advantage of you for the last 9 months. Like it makes you think they haven't turned around. They haven't right. Changed their ways in the last 72 hours. Like they're not out in 72 hours or back with a truck, then go the route you just mentioned. So,
yeah. And I should add too, that you are required to have 2 tarps, one for on the ground. You put all their belongings on that tarp on the ground, and then you put a tarp over it. So, you're not the bad guy. You're covering their stuff. They've had ample notice. Now, we just talked about that timeline. This case has been in court for 4 to 6 months. Yeah. They have had the opportunity to prepare themselves for this moment. And if they didn't, it is not your problem.
Well, I think we're going to wrap right there, and we'll probably have to bring you back on. Maybe we'll do a Tuesday tip and talk about cash for keys, because that's a whole nother 15-minute conversation. But man, we appreciate you coming on here today. So
yeah, absolutely. Thank you guys so much for having me back. It's always a pleasure.
Well, we'll skip the wrap questions because you've done them before, but you got a Chicago fact, Tom?
I do got a Chicago fact. All right, so Jessica,
we're playing for Rose Peterson, out of looks like Gilwood. And she bought a T-shirt. So Rose Peterson, if I get this question right, you get $50 Amazon gift card.
The second Gilwood one, nice.
Brought to you by Lenovo.
Mark gets first shot, then you get a chance to help him as well. So, Mark, you might know this one. I don't know. All right. So on Memorial Day, 1981, Dan Goodwin, he wore a Spider-Man costume and climbed all 110 stories of the Sears Tower. So if you remember this guy, and I think he did a few other crazy stunts, but a Chicago claim to fame is he climbed the Sears Tower. How many hours did it take him? And here's your multiple choice to climb 110 stories. 3, 7, 13, or 20?
I'll go with 7.
That was my gut too.
That is right, guys. Nice work.
All right. Rose Peterson, you win the $50 gift card brought to you by Renovo based on me just being lucky. So congrats, Rose.
15 stories an hour. It sounds doable for a professional.
That's what I was doing. I was doing the math. I'd never heard that story. I guess I have to go look that up.
Really?
That's crazy. Like that's like the crowds had to be gathering outside. Like, I mean, you don't go up more than an hour without like, that's what I was thinking too. Like, how long can this go before like, how do you even like get them down? Like you can't even like send a rescue guy up or something like that.
Yeah. I don't know, man.
I'm going to learn more about that.
For the 200th episode, you will climb the Sears Tower and see if you can beat 7 hours.
Yeah, I'll make it. It'll take me 2 stories to get to
I would watch that. I would show up for that. Definitely.
Like, what do you do? Do you climb with like I picture the suction cups? I gotta look this up. I gotta look it up. So,
we'll link to it. We'll link to it in the show notes with all the important eviction stuff.
Yeah. All right. Tom, thank you as always. Jessica, thank you. Awesome for coming back here. Listeners, we're going to have this show along with a whole bunch of other supplemental information on the website. Kind of time frames. We'll break some stuff down here because I think this is a lot of questions that you know and you need to know or be prepared for. Because I think when you understand what we talked about today, you start your process a lot sooner. You know that 3 months that you're trying to be a nice guy or give people a second chance. I think you might reconsider after you do this, and hopefully you've already reconsidered filing yourself. So, Jessica, thank you for being on. Tommy, thanks as always, and listeners, we will see you next week.
Thanks all.